In this episode, we're going to learn about a little-known insurance policy that homeowners can take out when they purchase a property. One that might cover them for things like the previous owner's illegal building works or an unexpected claim on part of the land that you thought you just bought. Curious? I am. Let's get started.
Welcome to Your First Home Buyer Guide, the podcast for first home buyers who want to move it along and become homeowners. But most importantly, it is for you to become an educated home buyer.
I'm Meighan and that was Veronica. We're both buyer's agents and probably old enough to be your mum. But it's a good thing because between us we've got over 45 years experience to share with you and bucket loads of stories about avoidable mistakes. Together, we're going to make sure you get unbiased and real information you can rely on. Allow us to guide you on your home buying journey. We want you to become an educated home buyer so that you can stop looking for your first home and actually become a proud homeowner.
We've got loads of great tips for you in this episode, and if you'd like more useful tools, head over to the website homebuyeracademy.com.au, and there you'll get access to our free mini course, How to Price a Property Like a Professional. You will also find the holy grail of home buying education, Your First Home Buyer Guide, the online course for people who want to become educated home buyers. We created this for you to help you get on the right path to home ownership for your first home and beyond.
But before we get into the interesting stuff in this week's episode, we've got the boring bit, the disclaimer. You of course know that nothing in this podcast is to be taken as personal advice. We always recommend getting the advice of an expert in their field who takes the time to understand your personal situation. We've done our very best to ensure that the content is correct at the time of recording. Things change rapidly, so always check with the relevant government authority and your trusted advisors to get the most up-to-date information.
Today we're talking about things that can go very wrong when buying a property and how we can cover ourselves against some things that are simply not discoverable when you do due diligence. And we have a guest expert to help us out. But before we get into that, what is your special house behind you in the video this week, Meighan?
Well, this is right on topic, as I try to be sometimes, but sometimes I just find really interesting things. But this particular one, if you can see, and you can't see my hand there, you can. If you can see that shed, I'm just trying to get it into the frame. Not going to work. If you can see the shed above my shoulder, exactly there, that particular shed encroaches on the property next door. And that was not discovered. This is not a property that we bought. That was not discovered by any process during the purchase. And in fact, the purchasers thought that perhaps they had a little bit more land the other way. The other owners thought they had a little bit of land the other way, and when there was finally a survey done, there was a disaster that unfolded for those people. So that's what we're talking about. One of the things that title insurance may cover you for.
All right. So our guest expert today is Paul Watkins from Stewart Title Insurance. So welcome, Paul. Thanks for coming along.
Welcome.
Thanks for having us. It's great to be on the podcast.
So really, really appreciate your time. So can you let's kick this discussion off by, if you can please explain for us exactly what title insurance is.
Sure. I mean, unlike most other types of insurance that home buyers are introduced to when they're looking at buying their first property, such as home contents insurance, that those insurances are looking at the protecting the house against things like storm damage and destruction. What title insurance does is it actually protects against risks that concern your actual title to the land, including any liability that might exist because of things like boundary encroachments that will then give rise to disputes about who owns what. That's a title issue.
Mm.
Also, things like did the previous owners over the last 20 years build anything on the property without a permit? Because if the answer to that is yes, then that gives local councils the authority and the power to issue building notices against the property. And under the council's powers, they've got, compulsion powers to comply with that notice. So that is also a defect in the title when somebody else inherits that risk. And there's a whole range of issues such as zoning and planning and regulations that govern the use of land, not just in New South Wales, but in every jurisdiction in Australia. And each year there seems to be more and more regulations about what you can and cannot do and how you can use your land. So if there's ever been over the course of the ownership of that property a breach or non-compliance with that planning or zoning in some way that's not disclosed, then that results in enforcement action being able to be commenced by the authority that's responsible for those things. And they're the sorts of risks that homeowners inherit when they buy a property. And they're related to title and not to the damage or destruction of a property. And that's really the domain of title insurance.
That is so interesting because we always talk, Veronica, when we talk to our students and our listeners, we talk about the need for protection of your income, so income protection. We talk about lender's mortgage insurance, which of course protects the lender. We talk about building insurance. We talk about strata insurance. We talk about contents insurance. So there's a whole lot of insurances that we talk about. But, this is a really interesting one because I want to give an example that's really practical, Paul, and if you can then address how this would work. So let's say, for example, there is a property that's being sold and as a buyer, you say, is that an approved structure? And they say, well, when we bought it, they told us it was approved. So perhaps the work was done 2 or 3 owners ago. And everyone's relying on this sort of, Chinese whispers of, yeah, it was all done fine. And, the people that we bought it off told us. Now, we as buyer's agents would, of course, then dig in and make sure that we got the evidence to support that. But let's say someone bought a property that had a deck that had been built and that deck failed in some way and there was an injury. Would title insurance come into play there, or is it not about that sort of public liability aspect? Is just about the structure?
That's right, yeah. So title insurance doesn't come into play where there's been a failure of a deck or something like that, or any sort of injury. But it might lead to a claim because, for example, that might lead to investigations about whether that deck was ever approved in the first place. And those investigations might lead to council saying, well, we're now aware of this deck because it's failed and there's been an injury. We're now aware of it. We've checked our records. We find no permit where a permit was required. And they might then issue a building notice on the property just to add a bit of insult to injury about the other things going on. So that's the sort of thing that title insurance covers. It's the building notice being issued by the authority because of the absence of a permit. And that's the common claim that we sort of get nationally.
What could that notice say? So I've had a building notice issued on me for a property that I purchased that...
Have you?
Yeah, I have. It was a retaining wall at the back of a property, my last property that I owned. So what might that notice say to the new buyers who were unaware of an unapproved structure? And what are the implications of that notice?
Yeah, sure. I mean, the building notices will all generally follow the same format because the legislation in each state, whilst it's different, has the same basic formula, which is the building notice will say the council as the relevant consent authority has now become aware that a structure has been built on this property without a permit in circumstances where a permit was required. You, as the new owner, are now required to show cause as to why the unapproved structure should not be demolished.
Wow.
And you now have 28 days or whatever the case may be, whatever the legislation in that state specifies, to now show cause. And what the show cause really is saying is that the onus is now on the homeowner, keeping in mind this homeowner who's received this notice has no idea about this unapproved structure. This might have been built 20 years ago.
Might have been built 5 years ago.
Exactly.
Yeah.
You now have to show cause why this structure shouldn't be demolished. And by showing cause, what that requires the homeowner to do is to get a builder or a building consultant to come in and say, okay, is the structure building code compliant? Is it structurally sound? Does it comply with the building codes as at the date the notice is issued? And this is where it becomes problematic, because where work is unapproved and that work maybe happened or was carried out, say, 5 years ago or 10 years ago, that work may well have complied with the building codes 10 years ago.
Yeah.
But you now have to demonstrate to council that it complies with the code as at the date the building notice is issued. And 10 years is a long time for the building code to move on and change. So in our claims experience, we find that once a building notice is issued, it's very, very difficult to satisfy that show cause element. And in fact, 9 out of 10 times, there is rectification works required. That's really what the building notice is saying. You must show cause why it shouldn't just be demolished. And if you can show cause, it can be rectified, then you are required to take following steps. So, for example, in Western Australia, you can apply for what's called a retrospective building approval certificate. In New South Wales, it's a bit more difficult. You can't actually get unapproved works retrospectively approved. The legislation doesn't support that. But what you can do is ask for council to issue a building information certificate for that structure, which bars council from issuing any demolition notices on it for 7 years. And you might even have to lodge a develop application for the continued use of that structure. So there are ways of regularising unapproved building work. But once a homeowner is served with that building notice, that's the basic steps. You now have to satisfy council why it shouldn't just be demolished. And then you have to take steps to have that unapproved building work regularised at your cost. And council doesn't care that the owner that the notice is served on was not the owner who carried out the works. The building notices get issued on the property, not on the owner at a particular or the person who carried out the works.
So let's
It's like Russian roulette.
Yeah, it is, isn't it? Yeah.
Let's take this example a little bit further, because I know that if a structure is built 20 years ago and there's no evidence, and it might be by the third owner ago, and there's no evidence that it was approved at the time, when you're trying to buy a property, particularly in a hot market, you don't have time to go to council and require what's called a GIPA to lodge an application for them to go into their archives, which takes 21 days, bring out that information so that you can verify it. Like, you've got to make a decision and buy the property or not buy the property without the information. So sometimes, as buyer's agents, what we do is it's not so much about what we can find out, it's what we know we don't know. We then know we cannot prove one way or the other whether it was done legitimately, because it's so long ago and nobody remembers, and in order to do so we don't have time within the period of time we need to do our due diligence when buying the property. So there's a risk there. But there's also circumstances where we might know that it was actually built without approval. So I'm wondering, if we went, okay, we're buying this property, there's a deck there, it was built 20 years ago. Scenario 1, we don't know because we cannot access that information in time. Scenario 2 is actually, well, the current owner sort of confessed to the agent that it was built illegally by the previous owner and they built it, they were okay buying it, they were okay with that. So in those scenarios, can we get title insurance in both cases? Or if we know it's not legal, can we not get title insurance?
So in the first case, absolutely, that's what title insurance is there for. At the end of the day, if you don't know whether something's approved or not, and it's very difficult to ascertain that approval status through GIPA or any other process, on GIPA, for example, a lot of the GIPA application, the results that come back, for example, won't contain plans because the council say, well, there's copyright in plans and we need to get the consent of the copyright owner before we release the plans. And without the plans, you really don't know what you're looking at. So certainly in the first example, that's our bread and butter.
Okay, so sorry, just because I'm not in New South Wales and not all of our listeners are in New South Wales, can you just explain what GIPA is? GIPA?
GIPA. Yeah. So it's an acronym that stands for a piece of legislation, which is basically the Government Information Public Access Act, which effectively replaced the sort of freedom of information regime in New South Wales. And there would be similar pieces of legislation in other parts of the country.
Great.
That provide a freedom of access of information for property owners. It's just that the amount of information that can be provided is quite limited. The timeframes can be very challenging for property transactions. So certainly in the first example, that is what title insurance is designed for. In the second example, which is the home buyer is aware there's an unapproved structure, whether it's being disclosed by the vendor formally or informally, they just know that structure, whether it's a deck or a garage or an extension, is unapproved. Can they get cover for under the title insurance policy? The answer to that is potentially yes. We do have what is called known risk cover. And we assess that on a case-by-case basis. So the first step would be for the home buyer who's aware of the unapproved structure to disclose that to us, to seek cover. And then our underwriting team would look at that and then form a view as to whether it's a known risk that we can provide cover for. If we can provide cover, the cover is quite limited. So it's capped at a monetary amount of maximum would be $5,000 of cover should there ever be a building notice issued in respect of that known unapproved structure. Some unapproved structures we simply can't provide cover for. So a perfect example of that might be a secondary dwelling or a granny flat. Yeah. A swimming pool. I mean, I know this is
interesting because that was a question I had.
But for things like that, we don't provide known risk cover, but we do provide known risk cover for things like decks, carports, garages. In WA, they use the word al fresco a lot, so we get a lot of unapproved al frescos. In fact, in a lot of parts of the country, particularly Queensland as well, given the climate, there's always some sort of patio structure. A lot of those patio structures are unapproved, and it's difficult to ascertain whether they even needed approval. So a lot of people just say, as far as we're concerned, it either is approved or never required approval. So we certainly are dealing with known risk inquiries a lot. What I suggest your listeners do is if you are aware of an unapproved structure, it costs you nothing to seek a known risk inquiry with us, and we can tell you very quickly whether it's something that we can provide some cover on or not.
Can I throw another scenario at you? And this has come up for us a few times, Veronica. I know we're like, I don't know, I need to know more. This comes up for us a lot, where an owner gets their application for building works approved. They go through the process of getting their inspections and their relevant certificates throughout the process, so at each sort of stage that's required. And the building work's finished, they do practical handover, and somebody forgets to submit the Form 21, which is the final certification. So council has potentially, or may not if it's a private certifier, but the owner has all of the certification documents along the way, but not final certification. Owner is under the assumption that everything's approved. They say, yes, everything's approved. We got everything done properly. We have so many times found that last and final certification isn't actually lodged. And in my case, where I had a show cause notice, it was for a retaining wall that was at the back of the block, and the people behind me made the complaint about it, and I had to go through the process and find the certifier. The certifier had passed on. I actually couldn't get that Form 21. Now, so in that case, Paul, what retrospective certification was required? Everything was compliant with the current building code. So, tick, 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 cost me some money to do that and a lot of heartache and trouble. Had I had title insurance, would have been a little bit more straightforward. But what happens in that scenario where it is truly believed that the work was done and everything was done, but the final document isn't there?
Yeah, we do get a lot of those sort of claims. So, as you say, if you had a title insurance policy, you bought the property, you saw there was an approval history, there's a permanent history for this property, what could possibly go wrong? And then you find out after settlement, once you're now the new owner, that in fact there is a certificate missing, and you now have to go forward and do all this work. That could potentially be a claim under the policy to the extent that council requires that final step to now be completed. And that's often what happens, is you have a situation where not all of the certifications are in place, it gets missed. Then, for whatever reason, in your case, you had a pesky neighbour, and that's how most of our claims become claims. It's the pesky neighbour issue. I often call title insurance a form of neighbour insurance because
I love that.
because that's really what triggers a lot of our claims. So, but another example might be that you have gone to council yourself to do further works on the property. You now want to put a pool in, or you want to do a granny flat, or you want to build a bigger carport. And it's in the course of that application that council says, oh, by the way, we've never actually completed the initial phase, and then you now have to do this. So that's certainly a title insurance coverage. Another one might be of interest to you. We get a lot of claims on this, is where you do get the final certificate. You get all the certificates, occupation certificates. But then you find, notwithstanding those certificates being issued, the work still doesn't comply with the approval. And we do get claims where the certifications might be in error, or the certifications, there's an assumption around whether that certificate covers off on certain things when in fact it doesn't. So an example we've had is that a house was constructed, the approved plan specified that there should be privacy louvers installed to windows on the outside facing wall. It was one of those 2-story houses where pretty much the whole wall was just one big glass window. And so the approved plan said, right, it had to have privacy louvers installed on that. Now, the builder missed that step. They didn't install the privacy louvers. But a final occupation certificate was issued, and everyone thought, well, the final occupation certificate is the certificate to show that everything's great. So no one thought twice about it. Now, it turned out that council then issued a notice on the property saying the house is in breach of the planning approval because the louvers were never installed.
Mm-hmm.
So we went back to the certifier to say, well, you issued a final occupation certificate on this property. The certifier said, yeah, we did, but the occupation certificate is simply certifying that the place is fit for occupation and habitation and meets all the requirements. And having privacy louvers on the outside of a house has no impact on our issuance of an occupation certificate.
Wow, interpretation of,
And so a lot of people, and we see this, a lot of lawyers and conveyancers and home buyers have this kind of perception that an occupation certificate is like a certificate of good health issued by the council or from a private certifier. If it's got an occupation certificate, it must be okay. But in most jurisdictions, occupation certificates are only addressing a very specific set of criteria for issuance. And it certainly shouldn't be interpreted as being a certificate that all conditions of the development consent or the development approval have been complied with, because it's certainly not that. And in New South Wales in particular, it's very difficult to get a certificate that has that effect. So you can even buy a property that has been approved, has occupation certificates issued, yet there is still work that doesn't comply with that approval or hasn't been completed in accordance with that approval, which is missed in the process. And it doesn't come into light until many years after settlement because of further works being done or a neighbour dispute or something like that. So that's certainly an aspect of title insurance that a lot of home buyers are very grateful for once they find out themselves in this issue. And they go back and say, well, how could I be facing this problem? Like your retaining wall, it's been approved. I've cited the approval document, but that's not the end of the story. There's still, does it comply with the approval? Have all the conditions of the development consent been complied with? And that process itself can be very tricky when you've got a combination of a council consent authority and a private certifier. There's a lot of gaps there.
Yeah, there is, isn't there?
So fascinating, because very
That's what
recently,
title insurance is for on that covered risk. It's just for protection in those circumstances where you may never think you need it, but as our claims experience shows, right, sometimes you do. And that's really the point we tried to make, is that most home buyers don't think twice about spending thousands and thousands of dollars every year insuring their property against fire, for example. But if I canvassed 100 people and said, how many times has your house burnt down? Most will say, well, never. Yet you're insuring against that risk every year, as you should. But people don't think about these things that we're talking about are much more common than houses burning down. I mean, we're dealing with these sorts of claims nationally every week, and they're much more of a common occurrence than a lot of the risks that are covered under your home and contents insurance that covers things like, bad storms, hail, flood, if you can get that kind of coverage. Things like this are just becoming more and more commonplace and more in need of insurance cover.
Now, the interesting thing too here is you only pay one premium, don't you, here, as opposed to every year you pay your home and contents insurance. So you pay this, at the point of or round about the point of purchase. I understand you can actually buy it retrospectively. I understand you have policies after purchase. But let's go to some of the things that we can't discover through our due diligence process, because, we teach a due diligence process in your first home buyer guide, and certainly Meighan and I follow rigorous due diligence process in our buyer's agency businesses. We're actually horrified that a lot of, as a bit of a segue, buyer's agents aren't taught how to do due diligence. So if you are going to engage a buyer's agent and you do our course, you'll probably know more than most buyer's agents out there, which is actually shocking. But Meighan and I are sticklers for this stuff. But even so, we know that there are certain things that cannot be discovered. And so can you sort of share with us some examples of what cannot be discovered during the due diligence process, even a rigorous one, and therefore, where the need for cover might arise?
Yeah, I mean, certainly it's different from state to state. But the general rule of thumb is, of course, when you talk about due diligence on a property, one of the big ticket items are the survey or the boundaries of that property.
Yes.
Yeah. And so, unfortunately, a lot of home buyers now are starting to rely on satellite services, things like Google Earth and other subscription services, like the image that's in the background there, where you can kind of zoom in on a property and it looks like a line shows where the laundry is. And so, is that part of your due diligence? Is that what you're doing? If that's what people are doing, then that's not accurate. You can't rely on that. Those satellite images are simply photos from a satellite or a drone that are taken at certain points in the day, at certain times, and then they're superimposed onto some kind of Google map kind of exercise. And we use this mapping services ourselves, and we can see over a period of years or months the houses move in the boundaries relative to what time of the day the photographs were taken.
And the angle, if you're directly above the house, it's going to be straight, but if it's the one next to it or the one on the other side, they're going to be slight angle.
That's right. And so you can have 5 images that are taken over 3 months, and the house is perfectly sited within the legal boundaries according to that image. 3 months before that, half the house can be hanging over the boundary into the neighbour because of the angle of the photo. So in terms of that kind of due diligence, the only way you're going to be able to verify the legal boundaries is to get a surveyor to do a proper identification or boundary survey. That comes with a big price tag and a timing issue. And the other issue, which I think home buyers would be very interested to know about, is with due diligence. Due diligence is really only as good as the rights and remedies that it gives you. once you've done it. So traditionally, when as a property lawyer myself, I used to say to my clients, due diligence is all about forming a view, having an informed view about whether A, you want to buy this property at all, and B, what price you're going to pay for it.
Yep.
So traditionally, in the good old days, you do a lot of your due diligence before you made an offer or before you became bound by a contract.
Yeah.
That's changed somewhat. I mean, in the current
In a hot
environment.
market.
Very, very market dependent. Yeah.
Then, of course, if you sign a contract, then you get a survey report, and the survey shows that your eaves and gutters encroach over the neighbouring property by 3 millimetres. The question then becomes, what rights does that give you under a contract?
Mm.
And that's different depending on whether it's unconditional and which state. Yeah.
And so that's why the utility of due diligence is dependent on what the market's doing, whether you're actually lining up with 90 other people and elbowing them out of the way in a rush to sign the contract to secure the property, or whether you're spending $5,000 on due diligence only to lose that property because somebody comes in and buys it under you. So I find it very problematic for home buyers being presented with the due diligence. It's kind of like, well, what do we do? How much time have we got to do it? How much money have we got to spend on it? And at the end of the day, if I do it, what's it going to do for me? What rights is it going to give me before or after contract? So certainly the title insurance value proposition is, we certainly suggest everybody should look at doing their due diligence. In terms of boundary risk, the only way you're going to know the boundaries are by getting a survey. That's it.
Can I just add to that? You talked about the satellite imagery being a part of how some people determine whether a property is within the boundaries or the other thing that people do is look at the fences. And, and I just want us to really, be clear with everybody. Where a fence is only where someone's chosen to put it. It's not an indication of a boundary.
I've got a story on that. Have I shared you my fence story before?
Have.
Yeah, well, so I've actually bought a property and I had a survey in the contract. And this is a long time ago before I became a buyer's agent. I never really put two and two together and checked it. But when the fence needed to be replaced, I just agreed. It was an investment property and I agreed, yes, go ahead. I'll pay half the fence. It was replaced where it was built. And then when I went to renovate that property sometime later, that's when I discovered the fence was actually built 1 metre onto my land for quite an extensive period, length. And it had to be moved because I couldn't do my extension whilst that fence was actually in that position. So it needed to be moved. And then we discovered that the house next door had all these services bolted onto their side wall, encroaching on my property. And then if I put the fence where it belonged, they wouldn't have access to their services, hot water system, things like that. So then they had to go and move. It was the house next door was public housing, which is another story about due diligence and assumptions that were made before I became a buyer's agent. And anyway, they had to go and move all their services because by rights I could. But they got bolshy about it, and for a minute there, it looked like they were going to take me on and to say, no, the fence had to stay where it was. And I had approved plan. Anyway, it all worked out in the end, but it could have been a real nightmare. And that's someone I was a real estate agent at the time. I just wasn't a buyer's agent. So
it actually worked in your favour. So that meant that you got a metre more than you thought that you'd physically inspected.
Oh,
but it could go the other way, couldn't it? It could be that
absolutely go the other way.
A metre in the other, and you think you've got all of this beautiful yard and all these facilities and all this ability. And the pool over there, and we'll put the trampoline there, and suddenly you get a survey back, and you don't have anywhere near the room that you thought you had.
This is pretty much what you just described is a typical boundary title insurance claim.
Yeah.
This is what we're dealing with every day all around the country.
It's common.
It's a common issue.
Yeah, because fences were just put where people thought the boundary was. Yeah.
Well, that's right. And the mistakes can be
compounding.
Or
somebody then builds a shed. Imagine they think they've got that extra metre, they then go and build a shed on that spot, and then all of a sudden,
which is what happened here.
Yeah, exactly right.
Absolutely, and unfortunately, yeah, it's a compounding problem. The other issue, I mean, with the example that you just gave, Veronica, it's like you had to put your fence back towards the neighbour, but in some jurisdictions, WA, Victoria, depending how long that fence has been there, the fact that the neighbours have enjoyed that land and in fact built services, that could give rise to an adverse possession claim.
And that's what they threatened me with. Yeah.
Yes.
Interesting. Yeah. Yeah.
And so, you know, there are also legal issues that the title insurance policy responds to by providing a legal defence to those issues. So just because the fence is in a certain position certainly doesn't mean that that's where your legal boundary is. But in a lot of cases, it's not simply a matter of saying, oh, okay, I've discovered the boundary fence is a metre in on my land, I'm just going to move it. Now, in some cases, you can, and that's great if you can. But in a lot of cases, you have to consult with the neighbour about that, and then suddenly they get all aware of their legal rights. They might get some legal advice, and then you're getting a letter from the neighbour's solicitor saying, well, my clients have enjoyed this land for the last 25 years, and it's not going to move the fence. As far as we're concerned, we now own that land.
Yeah.
And if you take any further attempts to move the fence, we'll make a possessory application and have the boundaries realigned.
And what I want to do is say on that title insurance does not replace due diligence, because if you can find that out in the due diligence process, which in my case I could have, because there was a survey in the contract, right? So I could have, if I knew then what I know now, I could have found that out. And then I could have understood better the risks around that. And I might not have decided to buy that property, potentially, you know, because I might have thought, shit, I'm losing however many square meters of land here, and that's potentially something that I might not be able to reclaim. You know what I mean? So I think it's really important that due diligence is done, because it does flag for us where this could become a problem. If you go and get title insurance, it's well and good that all your legals might be paid for and all the rest of it, but you might never get the land back. And then you're still suffering and you're getting less than, you know, well, in my case, I didn't think I was paying for it anyway. But look, the point being, you still got to go through a pretty horrible process. And then potentially the outcome might not still be great for you. So I think that title insurance is fantastic, but it goes hand in hand with really rigorous due diligence, in my view.
Yeah. And that's a position that we support as title insurers, where we don't want to send a message to the market. Oh, don't worry about due diligence, just insure. Certainly, you know, to go back to your original question, due diligence is only as good as the information that's available.
Yes.
And that can be provided. And that's really where you're not going to necessarily find out all the potential issues on that property.
No.
For example, you know, again, your due diligence about building approvals is going to give you a basic permit history if you can get it. You may not be able to get approved plans. So therefore, you're not going to know whether all the conditions of the consent have been complied with, unless you spend maybe a few $1,000s on engaging someone specifically for that purpose, and depending on how much time that's going to take. You know, then you've got things like planning and zoning. Does the property comply with the zoning of that property? So you can look at what the zoning objectives are, but then you need to engage an expert potentially to go further into that. So there's a lot of issues there, and it gets worse every year, because as for conveyancers and lawyers, every year state governments make them do more work. That they're now tax collectors for foreign buyer duty in a lot of cases. They've now got a lot of VOI to do and verification and anti-fraud measures, and each year it becomes harder and harder for conveyancers and lawyers to keep on top of what they're expected to do. And what we've seen over the years is that when they're collecting taxes and verifying identity, it presents a challenge now for the due diligence aspect. So the onus then becomes more on the home buyer. You have to do that. Buyer beware, it's a matter for you. And so it's just a question of what is available out there, what searches do you do, how quickly are they going to come back, and how good are the records that are kept by council about certain things. It can be a bit of a tricky situation for some buyers in some council areas as well.
I'm really keen to also understand strata. Where might it does title insurance? Is it something that is appropriate in a strata for a strata property? And can you give us some examples?
Absolutely, we have a lot of strata claims. We have a strata title insurance policy that's targeted specifically for strata title properties. Most common claims that we get on strata are breaches of bylaws relating to things like how many reverse cycle air conditioning units you can have in an apartment. So, for example, a lot of bylaws might say that each particular apartment can have one reverse cycle air conditioning unit because the outside unit sits on the balcony, and people don't want 4 of those because it looks very ugly from the street. Or in more complex and sophisticated strata complexes, you might have to use the air conditioning core system in that building. You're not allowed to have reverse cycle air conditioning systems at all. And those are issues that are generally breached by homeowners. They put more than one system in, or they don't hook into the air conditioning system. They just put 2 reverse cycles in. So that's a common issue. The other issue we often get too is that when you look at strata as a legal concept, particularly in New South Wales, when you buy a strata title apartment, all you're actually buying is the airspace.
The paint inwards.
Correct, absolutely. And then the owners corporation actually own the building. And so if you want to make some alterations to that, you need to go to the owners corporation because you're interfering with the common property.
Yeah.
So a classic example we see is, you get this strata apartment where it might have been built in the 50s or 60s or 70s, and it's got a little archway in it. Yeah. So to go from the lounge room into the dining room, you go through a little archway. And people don't like that. Oh, it's a bit pokey, a bit dated. I'm going to square that archway up. I'm going to expand it out. And look, it's an internal alteration. Doesn't affect anybody. I'm just going to go ahead and do that. What they don't know by doing that is that they're actually interfering with the common property because they're now chipping into the common property wall. And what they've done is they've actually breached the strata scheme rules that say you can't interfere with or tamper with the common property without the consent of the owners corporation or a special bylaw or an exclusive use bylaw that allows you to do that. So we see a lot of those sort of claims where there's just alterations done to the internal configuration of an apartment to make it bigger or open it up a little bit. We see a lot of special levy claims. I don't know if you have these issues with special levy.
Haven't heard. Oh, tell us more about this one.
So this is a situation where somebody's selling a property and there could be a big special levy that's kind of looming for some major capital works. There's not quite enough money in the sinking fund for that, so there's going to be a special levy that's going to be struck that could be significant. What we see often in New South Wales is the timing of that levy is going to impact on the marketability of that property. And so we've had a number of claims where our insured has bought the property, they've exchanged contracts, and they're now in the 42-day settlement period.
Yeah.
They get the strata certificate, and that comes back from the strata manager saying no special levies being struck as at the date that certificate's issued, but there's still 18 days or 22 days to settlement. And then somewhere between the date of that certificate being issued and settlement, an EGN is called, and 4 days prior to settlement, that special levy is struck. The buyer has no knowledge of that. They're not aware of that. They're
Wasn't discovered at the time.
The certificate that they're relying on says no special levy struck as at the date of that certificate.
Yep.
Then a week later or 18 days later, a special levy is struck, and the first thing that the buyer knows about it is post-settlement. They get their first quarterly strata levy notice, and lo and behold, there's one there for $64,000 being the special levy that was struck 5 days prior to settlement.
Right.
They're saddled with that.
Yep.
And that
An interesting
is
one.
a title insurance claim. And we see those claims quite often.
What if it was struck a year after they bought it?
That's different. That's not covered. So what's being covered here is that the special levy is struck prior to settlement.
Right. Right. Even if it was a week afterwards, the mortgage wouldn't be covered.
Correct.
Interesting.
And it's an unpaid, unknown special levy, and we're covering the purchaser's liability to pay that, which they weren't aware of. So we see those sorts of claims quite often. We had one recently where the insured bought a property thinking they were entitled to a storage cage or a storage container as part of the strata plan. It was highlighted on the strata plan as belonging to their lot. Post-settlement, they went down, found out there was still stuff in the storage container. They thought the seller had left their stuff there, made inquiries. No, they discovered that the seller never had the right to that storage container. It was actually the subject of an exclusive use bylaw in favour of another lot owner. And that exclusive use bylaw was not disclosed by the seller. It was a disclosure failure. So our insured bought the property thinking they had an entitlement to a storage area. In fact, that was subject to an exclusive use bylaw in favour of another lot owner, and they weren't aware of it. So these are the sorts of issues that we see in strata title properties. I mean, I could bang on about it all afternoon because we just had so many of these sorts of
Examples of it.
so many examples of absolutely.
Can I ask a really simple one? You know, when you're in an apartment complex and the bylaws sort of state what sort of flooring you can have, and, you know, people buy and they look at the floor and it's a lovely timber floor or, you know, tiles or whatever the case may be. We have learnt through our processes and experience that should have body corporate approval if you're the type of flooring that you have. And let's say you bought it and then it's discovered that there was no body corporate approval. The people downstairs are complaining about the noise from the floors, and you've got to spend $15,000 getting the floors correctly. Insulated. Insulated. Yeah. Is that the sort of thing?
Yeah, I mean, that's an example of the basic formula is that you buy a property, you then find out that there's something in relation to that strata property that where there's been a breach of the bylaw, being that something has happened in circumstances that required either body corporate or council, in some cases both.
Right. Yeah.
But in some cases it's just the body corporate. It required approval and approval was not obtained. And now
so many things now.
action is now being taken. So the key things for title insurance coverage is there's got to be enforcement. So in other words, if you just buy a property and then discover, this floor was never approved, but no one cares about it. It's just that you just know that.
Okay.
That's not going to trigger a claim.
Yeah.
What's going to trigger the claim is that as a result of that, the body corporate, the strata manager, or a local authority is now enforcing that breach. Is now saying, "Hey, we've now discovered this. You have to take action to rectify it." And that's what triggers the coverage under the policy.
Now, question, because people will be going to be thinking, oh, this is fantastic. We should definitely be taking out title insurance when we buy a property. And certainly, you know, next time I buy a property, I'm going to take out title insurance. So you can access it. I presume we're going to put the link to your website in the show note. But how much does it cost typically? I mean, I guess it's different for different size properties or value properties, but what's an expectation around the cost?
So the premium is payable only once. So we mentioned that before. It's not an annual premium. You pay it once on settlement, and then once you pay your premium on settlement, you're insured for the life of your ownership of the property. The premium is based on the purchase price. So we have it in bands. So, for example, in New South Wales, the bands are 0 to 500,000, then 500 to
Don't get much there.
exactly. Yeah, you might get a letterbox or something.
Yep.
So it depends on what what the purchase price is and what band it falls in. But let's just say, for example, we're dealing with something between 1 million and 2 million. Your base premium for that would be $1,000 plus GST and stamp duty. So it would be about $1,200 all up, and you pay that once, and then you're insured for the life of your ownership of the property. If you're buying under $1 million, so if you're lucky to snag a property for, under $750, for example, you'd be paying about $700, $720 or something like that. And for $3 to $4 million, you're paying about $2,500. $4 million plus, you're paying about $3. So
Right.
when you look at the premium in terms of how long you're going to own that property for, and if you want to calculate it that way, it's still pretty good value on a daily basis. But the important thing really is that it's not something that you have to pay every year. It's a one-off payment. And obviously for strata and for vacant land, because we also issue policies for vacant land, they're a bit cheaper. So, for example, for a strata property between 1 and 2 million, you're looking at under $1,000, at about $950 or something like that.
Got it.
It's going to be eaten up very quickly if there's an issue, isn't it? And just to use my example, that purchase was back in 2008 and it was $740,000. And the cost to rectify the works that I needed to do, and the consultants and the process that I had to go through was just over, I think it was over about $1,500 to, so that would have been well and truly covered because of that enforcement notice, that show cause notice.
Look.
And the reason I didn't do it, just so that people know, the reason I didn't just, I was renovating, so there was nothing that was there. Fences, I was actually doing everything. I just didn't realise that retaining wall had been engineered and approved and gone through that process. So, that was a person that had at that point in time 5 years buyer's agent experience. So there's still things to learn, but the title insurance would have been very handy.
Absolutely, and it could have been much worse. We've had a lot of retaining wall claims where, you have to demolish and rebuild the retaining.
Yeah,
it's 80 to 100 grand. I mean, they're just big ticket items. Absolutely. I should mention that the unapproved building work cover that we have is capped. So there is a cap on that cover of $160,000 per claim. So I wouldn't want your listeners to think that the cover doesn't have any kind of conditions or caps on it.
Okay.
Certainly for unapproved building work risk, and the risk we were just talking about with strata properties where something's being done where it doesn't comply with the bylaws, or that cover is capped at $160,000, but it's not per policy, it's per claim. So, for example, you could have an unapproved structure, and that first unapproved structure is going to cost $160,000. Well, that's the amount of cover for that. But you could have a secondary claim on another structure on that property, and that $160,000 cap starts again for that particular claim.
Oh, wow.
So it's not per policy, it's per claim. And we find that that's a pretty good cap in terms of most of the claims that we deal with nationally will fall well under that 160. On occasion, there are claims where the loss exceeds the 160, and in those circumstances, you're going to get covered up to 160. Anything above the 160 is going to be uninsured loss, unfortunately. but it's a necessary, I guess, component for us if we want to keep the premiums affordable. So affordability is a key priority for us. But to keep things affordable, there has to be a corresponding kind of tweak to the coverage. So that's the compromise that we've had to strike to keep those premiums at an affordable level.
Okay.
Great.
So then how do people access it? So you mentioned, I think earlier in the episode that this is usually, you access this through your solicitor, your conveyancer. For our listeners, if this isn't raised as an option by the solicitor, is that something that you'd sort of suggest that they do, that they ask the question?
Absolutely. So title insurance is generally, referenced or recommended by the conveyancer or the lawyer who's acting for the home buyer. You won't see us on the side of buses, or doing clever.
Yeah, they're not your customer, the lawyer. Yeah.
Yeah. So it's normally the lawyer or the conveyancer who will say, hey, you really should consider taking out title insurance. Now, having said that, we have over the last 20 years, we've generated a very large network of law firms, conveyancing firms that do that. But not everyone is aware of title insurance. Not all lawyers are conveyancers are. Yeah. They may well not even be aware or don't really know about it. So I hope there's some lawyers and conveyancers who are tuning into this podcast as well as home buyers. But look, if your conveyancer or a lawyer doesn't know much about it, there's nothing to stop you from ordering it directly through Stewart Title.
Okay.
You can do that. You go to our website. There's an order form there. You simply have to include on the order form that you are represented by a lawyer or conveyancer and tell us who they are. We just don't issue title insurance policies to self-represented buyers. So if you're out there and you're doing your own conveyancing, I say good luck to you, but unfortunately we
that is a big risk. Different regards, yeah. God.
But you can order a policy directly through us without being recommended or referred by your conveyancer or your lawyer.
Great. And so just to wrap this up, and thank you so much for your time today, Paul. It's been fascinating. We ask every guest a question, and that is, what is the one thing that you know now that you wish you knew when you were a first home buyer?
Wow, that's a great question. Well, firstly, probably title insurance. Self-serving response. That's certainly, I would probably say, I wish I had a crystal ball into where the property market was going to go. Because I probably would have bought more than one.
Oh, yeah. Okay. Interesting. Yeah.
Okay, so it's doing that longer term planning.
That's right. Yeah. I mean, my first foray into home ownership was an apartment, and it was very cheap, and it didn't stay cheap for very long. And in hindsight, I wish I had the foresight to buy maybe two of those, and I would have kept one, and I would have maybe sold one as an investment. But I think about what I paid for that property when I first bought it. I think about what it's going for now, and I weep with regret of woulda, shoulda, coulda. If I'd hung on to that thing, it might have brought my retirement date forward by a few years. But I guess I'm in the same boat as most first home buyers. It's always good to have that market intelligence, I guess, about not only what the market is now, but what we think it's going to be in 5 years.
Don't delay that decision if you are financially capable of making that decision.
If you're ready.
Absolutely. Absolutely. Yeah.
Yep.
Fabulous. I love that. Now, thank you so much, Paul. I've learned a lot today, and I think that's one of the things that I love about this podcast is, we've got a lot of knowledge, we've got a lot of experience between us. It's 45 plus years, but there's always something new that someone brings to us that we go, oh, okay, I can see how that fits for our first home buyers, and drawing that in and where the benefits sit and where the risks are and where the gaps are, because nothing's perfect. As you say, there's limitations. There's certain times you can claim, can't claim. So this has been really, really helpful. And if nothing else, that it raises the awareness for our audience to be ready to say to their solicitor during the conveyance process or prior to the conveyance process, talk to me about title insurance. I think that it's relevant here and I want it as an option. So raising that in the conversation, I think, is incredibly important. So thank you.
Well, you're welcome. You're absolutely right. I mean, title insurance is we look at it's a risk management tool. A risk management tool for buyers, helps them manage their risk. If you are going to have a link to our website, I would encourage all listeners to have a look at our consumer resources tab, because we've gone to great lengths to put a lot of information about what we cover, but also what we don't cover, so that
Nothing is completely risk-free. Yep.
Absolutely. Any decision to buy a title insurance policy comes with that knowledge that it's going to cover certain things, but it's going to not cover certain things. So we have a consumer guide that's just on exclusions in the policy. So I do encourage everyone to look at our website. We've gone the path of consumer disclosure in our business.
Yep.
So we've got a lot of information on our website, warts and all. We hide nothing. So we really do encourage people to go read that, inform yourselves about what's on offer and what's not on offer. And yeah, we really appreciate the opportunity to come on the podcast and talk about it. It's really it's been really great, and the questions have been fantastic. So yeah, thank you.
In this episode, we've only touched on a tiny part of the huge amount of things you need to know to become an educated first home buyer. There is so much more for you to do. You can learn all of the steps in the right order and avoid all of the mistakes that others have made in our 10-step online course for first home buyers.
If you'd like to learn more about the right process and avoid making rookie errors, become an educated home buyer. Head over to the website, check out your first home buyer guide, the course that we have created for you. And don't forget to subscribe to the podcast so you won't miss an episode. And if you've liked what you've heard today, please give us an iTunes review. It helps other people find us. And of course, I know it's a bit cringy, but we're going to ask for 5 stars. Thank you.
Thanks for joining us. We hope you've found this really useful. And if you have, please share the love with others who you know are in the same boat. We'll be back next week with more priceless stuff.